Clare Daly, please.
Thanks, Count Corla. Minister, obviously there has been some concern over the operation of the offices of the DPP, decisions not being made published, not being open to account and not being monitored. I note you said earlier you don't like to rush into things, but you have been in office now for 3 years and these matters have been in the public domain for quite some time. So I'm wondering what plans you have to reform the accountability and transparency of the office of the DPP.
Thank you. Minister.
Independence for prosecutors is a key principle underpinning, I believe, the rule of law in the international standards set by the Council of Europe, the United Nations and the International Association of Prosecutors. The independence of the Office of the Director of Public Prosecutions is set out and prescribed in Section 2, subsection 5 of the Prosecution of Offences Act 1974, which states, and I quote, "The Director shall be independent in the performance of his functions." The Office is accountable to the Committee on Public Accounts for administrative and statistical matters in accordance with Section 67, subsection 7, the Housing of the Oireachtas Inquiries, Privileges and Procedures Act 2013. The DPP is also accountable to the courts for her actions. The Office of the DPP also provides reasons to victims' families and close associates for its decisions not to prosecute in certain limited cases involving death through a project which was initiated in 2008. Speaking about the Reasons Project in 2008, Mr. James Hamilton, the then DPP, stated, and I quote, "The DPP prosecutes on behalf of the people as a whole, on behalf of society, not on behalf of individual victims. For this reason, I think the concept of accountability is not the appropriate concept to use when discussing the Office's relationship to victims. There is not or will not be accountability to victims in the sense that we will regard ourselves as bound by their wishes or allow them to determine how cases should proceed. The fundamental idea behind the change in policy is one of fairness, not of accountability. My department has no legal or administrative role in relation to the administration of the Office of the DPP, and there is no provision in the Government's programme for any amendment of the Prosecution of Offences Act 1974. However, the EU Directive on the rights, support and protection of victims of crime includes a requirement for victims to be informed of a decision not to prosecute and the reasons for the decision in Article 6, and for review of a decision not to prosecute, Article 11. I will be bringing forward legislation to transpose the directive, and the provisions relating to these aspects will be developed in consultation with the Attorney-General and the Director of Public Prosecutions.
Thank you.
I can say to the Deputy, I hope to bring forward that legislation in 2015.
Deputy Daly.
I think there are a number of important issues here. I don't think anybody would dispute the need for the DPP to be independent, but I reject the implication that there's a contradiction between independence and accountability. I think you can have both, and in a society which espouses to be democratic and open, I think it's very necessary to have both. Now, the Minister has acknowledged that he is going to finally, next year, bring in the EU legislation which would give victims the right to know why the DPP didn't make a decision to prosecute. That should have been done well before now. I'm glad you're looking at it now, but that's a basic human right to my mind. As you're aware, GSOC, for example, referred a number of cases to the DPP in relation to the Corrib incidents. Not one of them were prosecuted. Nobody got information about it. I attempted to put down a question last month in relation to the DPP, and I was told it was nothing to do with you or therefore with the House in that regard. And I'm wondering if the Minister could, and I'll just give one example to finish up, an example which is in the public domain of how we address this balance between independence and accountability. As you're aware, Mr Justice Barry, as part of a libel action in the case of Mr Ian Bailey, gave a writ, an extensive discovery order that the DPP should release files in its possession in relation to Ian Bailey and copies of all statements which the DPP had, which cast a doubt on him being involved in the murder of Sophie Toscan de Plantier, and documents suggesting that he was of good character. Now, the DPP furnished 700 statements, and then it furnished a list of other documents which they said they couldn't release because of confidentiality. Nowhere did they provide information on a critical previous DPP's critique of that case, which exonerated his character. That decision And that failure to adhere to a court order by the DPP has in essence been a serious problem for this man and his liberty potentially. And I want to know what you, as the Minister, who does have a role for justice and accountability, are going to do about it.
Well, the Deputy just gave the example of why we need an independent DPP that isn't subject to reporting to Parliament or to a government minister, an independent DPP who can make prosecutorial decisions based on the obligations of his office or her office and the provisions contained in relevant legislation, and who cannot be pressurised in Parliament by any deputy on any particular case or issue. The Deputy classically illustrated the difficulties that would arise if the DPP was so accountable. On a daily basis, we'd have Deputies Daly and Wallace naming individuals in this House, raising specific cases, making comment that could be prejudicial in circumstances where court proceedings exist. And instead of the DPP carrying out their role, you would have a government forced to politically interfere. Now, that is exactly what we don't need. That would be contrary to the public interest. And could I draw the Deputy's attention to the Venice Commission's 2010 draft report on European standards as regards the independence of the judicial system, in which it states, and I quote, "Accountability to Parliament in individual cases of prosecution or non-prosecution should be ruled out."
Thank you.
I wasn't banding around any allegations. We were speaking of matters which are in the public domain. And the point I was making, which maybe you didn't fully understand, was that in this instance it has been demonstrated that the DPP failed to adhere, actually breached a court order by Mr Barry White, a discovery order. They did not adhere to that order. They breached it. Who and to whom is the DPP accountable for breaching court orders? If you could enlighten me, if in the national parliament in issues of such public interest we're not allowed to raise them.
I thought the Deputy knew the answer to the question she's raising, but I think she's only raising the question to grab a headline. If the DPP or anyone else doesn't comply with court orders, who are they accountable to? The court. Are the court procedures in place to deal with any individual engaged in litigation of any description, be it civil or criminal, who it's alleged doesn't comply with court orders? Of course they are, and that's an issue that the courts address. It isn't an issue for Parliament to address, nor is it an issue on which prejudicial comment or judgments should be expressed by members of this House if matters are still current and before our courts. And I think it's unfortunate that the Deputy this morning has travelled this route, but I think it's helpful to illustrate the frailty in her case and to illustrate the dangers posed by her suggestion that the DPP should be accountable to this House for the manner in which prosecutorial decisions are made. But I do believe and support, in the context of victims' rights, the enactment of new legislation to incorporate the new European measure, which I was very supportive of as Minister when it was going through the Council of Ministers. The Deputy may not be aware that I previously published 2 pieces of legislation on victims' rights. It was the most recent one in 2002, and that the EU measure, together with the previous legislation that was drafted, will inform the content of what we bring before the House, which will not, in the context of victims' rights, be minimalist, and may indeed address some issues that we're not obliged to address under the European Union provision for the benefit of victims of crime.